The moment the fundraiser appeared, the tone shifted. Not because anyone was surprised that Patrick Rourke wanted legal help, but because of who the help was being asked from when it was being asked, and what the underlying allegations actually involve. Patrick had already been arrested. He had already been charged. 5 felony counts tied to alleged financial exploitation of intellectually disabled adults connected to the Whittaker family. That context matters, because this was not a traffic ticket. This was not a misunderstanding with paperwork. This was the state of West Virginia alleging that money raised in the name of vulnerable people was misused. And then came the fundraiser, what the GoFundMe was asking for, and why it triggered pushback. The GoFundMe page, whether started by Patrick directly or by supporters acting on his behalf, had one stated purpose: raise money so Patrick could hire a private attorney instead of relying on a public defender. On its face, that request isn't illegal. Defendants raise money for legal defense all the time, but context is everything. This case centers on allegations that Patrick took advantage of people with intellectual disabilities, people who were the reason money flowed to him in the first place. That's why the optics landed so hard. To many observers, it looked like this: money allegedly taken from vulnerable people, arrest, immediate attempt to raise more money from the public. And that is exactly where outrage started. The public reaction wasn't random, it was procedural. What followed wasn't just comment section anger. Multiple complaints were reportedly made directly to GoFundMe. Not emotional complaints, not moral arguments, policy-based complaints. GoFundMe's terms are explicit about fundraising tied to ongoing criminal cases, especially when the alleged crime involves financial exploitation. The platform reserves broad discretion to remove fundraisers that appear to benefit from harm, deception, or misuse of funds. And in this case, the complaints argued exactly that Patrick should not be using a crowdfunding platform to fund a defense against allegations that he financially exploited others through online fundraising and content. GoFundMe reviewed it, then they took it down, and that decision mattered more than people realize. Why the takedown was a turning point. When a platform like GoFundMe removes a fundraiser, it isn't making a legal judgment about guilt, but it is making a risk judgment. The platform is saying, this creates too much exposure. This conflicts with our policies. This cannot stay up. Reports indicate that donations were refunded, which means Patrick was suddenly back at square one, without a defense fund, without a platform, and now with even more scrutiny attached to his name. Because a takedown like that becomes part of the public record of the controversy. Why this hit harder than online criticism? Patrick had already been dealing with harsh commentary online, but commentary fades. Platform action doesn't. The removal reframed the conversation from, "Is Patrick guilty?" to, "Why does this look like a repeat of the same pattern?" That question is far more dangerous than insults, because it goes to credibility. The content fallout that followed. After his release, Patrick posted a handful of low-key videos, clips of his dog, short outdoor moments, nothing related to the Whittakers. But the response was immediate. The comment sections were not supportive. They were brutal, not because of rumor, not because of hearsay, because people were now connecting dots. Arrest, charges, fundraiser, takedown. That sequence told a story many people didn't like. And once public sentiment hardens in cases like this, it rarely softens quickly. The question everyone started asking: if Patrick didn't have money for a lawyer, Where did the money go? That question may or may not have a simple answer. Taxes, expenses, mismanagement, ignorance, all of those are possible, but none of them erase the perception problem. The public was being asked to financially support someone accused of exploiting others financially. That contradiction is what fueled the outrage. Why comparisons to Eric kept coming up? Almost immediately, attention shifted to Eric Carroll. Why hasn't Eric been charged? Why is Patrick the only one arrested? Why is the GoFundMe about Patrick when the family is still split? Those questions didn't start with the fundraiser, but the fundraiser amplified them, because asking for public money invites public comparison. And in this case, the comparison didn't favor Patrick. The public defender argument didn't land. Supporters tried to reframe the fundraiser as necessity. Public defenders are overworked. The system is unfair. Patrick deserves a real defense. All of that may be true, but it collided with one immovable fact. Public defenders exist specifically to ensure that lack of money does not equal lack of defense. Patrick may prefer a private attorney, but preference is not the same as injustice, and preference does not override optics. The deeper issue the fundraiser exposed. Underneath all of this is a bigger, quieter question. Was Patrick operating with intent or ignorance? Some observers believe this case reflects malice. Others believe it reflects someone unprepared for the legal, financial, and ethical realities of monetized social media, especially when vulnerable adults are involved. Contracts, percentages, taxes, consent, representation. These are not intuitive systems. And social media exploded before regulation caught up. That ambiguity may matter later in court. But in the court of public opinion, ambiguity rarely protects anyone. Where this leaves Patrick right now, as of this stage, the fundraiser is gone. The charges remain. Public sentiment has hardened. Legal outcomes are unknown. What seems most likely, based on similar cases, is not a dramatic trial, but a negotiated resolution, restitution, restrictions, and removal from proximity to the family. That outcome would not mean innocence. It would mean containment, and containment is often how the system resolves cases where harm is real, but intent is contested. The line the GoFundMe crossed. At its core, the outrage wasn't about Patrick wanting help. It was about who was being asked to help. Because the internet didn't come together for Patrick. It came together for the Whittakers. And asking that same audience to now fund his defense felt, to many, like a reversal of moral direction. That's why the reaction was swift. That's why the takedown mattered. And that's why this fundraiser didn't just fail. It reshaped the narrative. We'll examine the legal and ethical difference between restitution and fundraising, why courts treat them very differently, and why that distinction may ultimately matter more than any GoFundMe ever could. Do you think crowdfunding a defense in an exploitation case crosses a line, or is it just reality of the system? Once the fundraiser disappeared, the conversation moved past outrage and into something more important. How the legal system actually views money in cases like this. Because here's the part that often gets misunderstood. Raising money for a legal defense and being ordered to repay alleged victims are not just different things. They sit on opposite sides of how courts evaluate responsibility. And in cases involving vulnerable adults, that difference matters a lot. The core distinction the public often misses. A legal defense is about protecting the defendant's rights. Restitution is about repairing harm to the victims. Courts treat those two purposes very differently, especially when the alleged crime involves financial exploitation. That's why the GoFundMe didn't just feel tone-deaf to many people. It felt backwards. Because from the system's perspective, the first financial question in a case like this is never, how does the defendant fund their lifestyle or legal preferences? It's, were vulnerable people harmed? And if so, how are they made whole? Why restitution comes first in exploitation cases. In cases involving alleged exploitation of intellectually disabled adults, restitution is not optional window dressing. It is central. If prosecutors believe money was misused, diverted, or improperly retained, they are far more focused on tracing funds, calculating loss, determining benefit, identifying who was deprived. That's why so many cases like this end not with dramatic prison sentences, but with structured outcomes, restitution orders, financial restrictions, no contact conditions, probation. Those outcomes are designed to stop the harm and repair what can be repaired. Crowdfunding a defense does none of that. Why crowdfunding a defense triggers scrutiny here? Defendants crowdfund legal fees all the time, but not all cases are treated equally. The scrutiny increases when the alleged crime involves money. The money came from public sympathy. The alleged victims are vulnerable. The defendant was a central organizer. All four apply here. So when Patrick Rourke or his supporters turned to crowdfunding, the question wasn't, is this allowed? It was, is this appropriate under these facts? And platforms like GoFundMe are extremely sensitive to that distinction because they've been burned by it before. They don't want to be seen as enabling someone accused of misusing funds to raise more funds from the same public ecosystem. Why courts don't care about public defender versus private attorney arguments. A recurring argument from supporters was that Patrick needed a private attorney. But from a court's perspective, that argument doesn't carry much weight. Public defenders are constitutionally required to provide competent representation. Courts do not assume that choosing a public defender equals injustice. Preference is not a legal harm. So when a defendant says, I don't want a public defender, I want a private lawyer, the system hears, this is about comfort and strategy, not access to justice. That distinction matters when resources are limited and victims are still waiting. The optics problem that won't go away. Even if Patrick genuinely believed he did nothing wrong, the optics remain difficult to overcome. Here's why. The public did not rally around Patrick because of his legal plight. They rallied around the Whittakers because of perceived vulnerability. That emotional foundation does not easily flip. So when the same audience is asked to fund Patrick's defense, many people experience that as a moral reversal, from protecting the vulnerable to protecting the accused. That's not how collective sympathy usually works. The role ignorance might play, but only to a point. Some observers believe this case reflects ignorance more than malice. Social media monetization is still relatively new territory for many people. Concepts like revenue splits, tax obligations, consent standards, contracts, fiduciary responsibility are not intuitive. It's entirely possible that Patrick did not fully understand how money should have been structured, how percentages should have been calculated, who was responsible for taxes, how consent should have been documented. that may matter later in negotiations. But ignorance does not negate responsibility, especially not when vulnerable adults are involved. The law is unforgiving on that point. Why everybody does it is not a defense. Another argument that surfaces in cases like this is comparison. Other creators monetize families. Other channels raise money. Other people didn't get arrested. That argument rarely works because exploitation cases are not built on comparison. They are built on specifics. Who controlled the money? Who benefited? Who was harmed? Who had capacity? If those answers point in one direction, what others did elsewhere is irrelevant. Why a plea resolution is more likely than a trial. Given the facts as publicly known, many legal observers expect a negotiated outcome rather than a full trial. That doesn't mean the case is weak. It means the system is pragmatic. Trials are expensive. Victims wait longer. Outcomes are uncertain. In cases where restitution can address harm, risk can be managed, future access can be restricted, courts often choose containment over spectacle. That would likely involve repayment amounts set by the state, no contact orders with the family, limitations on future fundraising or content, probation rather than incarceration. Such outcomes are common in non-violent exploitation cases. Why the fundraiser made that path harder? Ironically, the GoFundMe may have complicated Patrick's position rather than helped it, because it reinforced concerns about financial judgment, optics, reliance on public sympathy, failure to prioritize restitution. Even if none of that becomes evidence, it shapes perception, and perception matters during negotiations. The question that still hangs over everything. At the center of this is a question the fundraiser never answered. If money is available, why not direct it toward restitution? That question doesn't presume guilt. It presumes responsibility. And responsibility is what courts care about most. Where this leaves the case now. At this stage, Patrick's situation appears to be narrowing, not exploding. The loudest reactions have passed. The fundraiser is gone. The process is moving forward quietly. What remains is a recalibration from public sympathy to legal reality. And legal reality is less interested in outrage than it is in resolution. We'll look at the side characters that emerge during this phase. Why secondary voices often complicate cases rather than clarify them, and why silence sometimes does more legal good than any post ever could. Do you think restitution should come before fundraising, or should a defendant's defense always come first? By the time the fundraiser was removed, something else had already happened to the case. It got crowded, not with new evidence, not with new filings, but with voices. And in situations like this, side characters rarely help. More often they complicate, distort, and sometimes even damage the very people they claim to defend. This is the part of the story most audiences don't like because it feels uncomfortable to admit. Not every voice improves clarity. Some voices increase risk. How side characters enter a case. Side characters usually appear at the same moment scrutiny intensifies. Arrests happen. Charges are announced. Fundraisers fail. That's when people who were previously quiet begin speaking loudly. Friends, associates, peripheral figures, people with partial access, old grievances, or online platforms of their own. They often believe they are helping. In reality, they are rarely operating with legal awareness. Why side narratives are dangerous in active cases. The legal system does not process cases the way social media does. Courts don't care who seems honest. They don't care who talks the loudest. They don't care who tells the best story. They care about consistency, restraint, documentation, credibility. Side characters usually undermine all four. When multiple people begin posting emotional defenses, speculative accusations, contradictory explanations, exaggerated claims, they create confusion, and confusion never benefits a defendant. The Brian problem. When peripheral voices hurt more than help. During this phase, attention shifted briefly to people like Brian, figures adjacent to the situation but not central to the charges. The problem with these figures isn't just credibility, it's volatility. When someone has admitted histories of dishonesty, inconsistent storytelling, emotional outbursts, unverifiable claims, they become liabilities. Even if they intend to defend someone like Patrick Rourke, they end up doing the opposite. Why? Because investigators don't separate narratives the way audiences do. They look at the ecosystem, and a chaotic ecosystem raises red flags. Why comparisons don't save anyone? Some supporters attempted to defend Patrick by contrasting him with others. He's not as bad as X. He didn't lie like Y. He didn't do Z. That framing doesn't work legally. Exploitation cases are not comparative. They are contextual. The system asks, what did this person control? What did this person benefit from? What did the vulnerable party lose? What obligations existed? What someone else did or didn't do is irrelevant. And dragging in side characters only shifts attention away from those core questions. Why silence is often the smartest legal strategy. There is a reason attorneys advise clients to stop talking, not because truth is dangerous, but because inconsistency is. Every public statement can be misquoted, can be contradicted, can be reframed, can be used to assess judgment. When a defendant or their circle continues to post, argue, explain, or defend, they create a moving target. And moving targets are easier to hit than people realize. Silence, by contrast, stabilizes narrative, limits exposure, prevents escalation. It doesn't mean guilt. It means discipline. Why? Explaining rarely fixes perception. Another mistake side characters often make is over-explaining. They try to justify decisions, reinterpret timelines, assign blame elsewhere, soften conduct after the fact. But explanations that arrive after consequences are already unfolding rarely land as intended. They often sound reactive, and reactivity suggests pressure. Pressure suggests vulnerability. The social media trap. When familiarity feels like authority. One reason side characters gain traction online is familiarity. Audiences feel like they know these people. They've watched them, heard their voices, seen their emotions. That familiarity creates a false sense of authority. But familiarity is not credibility. Investigators don't care who has a following. They care who has records. And side characters rarely have those. How this impacts the Whittaker family. Every time the conversation shifts to side figures, the Whittakers fade further into the background. That is not accidental. Noise distracts. Drama diverts. Arguments dilute focus. The more the case becomes about personalities, the less it becomes about restitution, reunification, protection, oversight, and that is the opposite of what vulnerable families need. Why courts prefer fewer voices, not more. From a procedural standpoint, fewer voices create cleaner outcomes. Fewer voices mean fewer contradictions, fewer misunderstandings, fewer opportunities for misstatement. When many people speak publicly, courts have to work harder to separate signal from noise. That slows resolution, and delay is another form of harm for vulnerable parties. The illusion of helping. Many side characters genuinely believe they are helping by defending reputations, attacking critics, controlling narrative. But from the system's perspective, those actions often look like interference, instability, lack of boundaries. None of those help. They raise questions instead of answering them. Why Patrick's case became harder, not easier. Between the failed fundraiser, public defenses, side character noise, and ongoing commentary, Patrick's situation did not stabilize. It fragmented. That fragmentation doesn't determine guilt, but it affects posture. A fragmented posture makes negotiated outcomes harder, not easier. Courts want assurance that future conduct will be restrained, predictable, and compliant. Noise suggests the opposite. The role Eric still plays in the background. While attention swirled around Patrick, questions about Eric Carroll never fully disappeared. But the more side narratives emerged, the easier it became for the core issues to blur. Who controlled what? Who benefited how? Who had authority? That blurring doesn't protect anyone. It just delays clarity. The lesson this phase reveals. If there is one takeaway from this stage, it's this. Cases don't collapse because of evidence. They collapse because of chaos. And chaos is often self-inflicted. Where this leaves the story now. At this point, the fundraiser is gone. The charges remain. Side noise has peaked. The system is moving quietly. This is typically the moment when things either calm down or escalate behind the scenes. We'll look at where cases like this usually go next, plea paths, restitution frameworks, and why social media outcomes rarely resemble courtroom outcomes. Because the internet wants drama. The system wants closure. Do you think public defenses help defendants? Or do they usually make things worse once charges are filed? By this stage, most public-facing energy has already burned off. The fundraiser is gone. The comment sections have peaked. Side characters have said their piece. And now the case enters the phase that almost never looks dramatic from the outside, but is decisive on the inside. This is the phase where the legal system stops reacting to noise and starts narrowing outcomes. Why the internet's expectations are usually wrong. Online audiences tend to expect one of two endings. Total collapse. Charges get dropped. Total destruction. Maximum prison sentence. Both are statistically unlikely. Most nonviolent exploitation cases involving money, content, and vulnerable adults resolve in a third way. Structured containment. That means the system focuses less on punishment and more on control, repair, and prevention. This is where reality diverges sharply from social media narratives. The prosecutor's actual goal at this point. Contrary to popular belief, prosecutors are not trying to win the internet. Their priorities are far narrower. Can the harm be clearly established? Can the financial trail be proven? Can future risk be reduced? Can the victims be protected without prolonged exposure? If the answer to those questions is yes, the incentive to drag a case through trial drops significantly. Trials are expensive. They delay restitution. They expose vulnerable victims to further stress. That is why prosecutors often prefer negotiated resolutions when possible. What negotiated resolution usually looks like. In cases similar to this one, involving allegations tied to online monetization and vulnerable individuals, negotiated outcomes often include some combination of restitution, a court-ordered repayment amount based on documented loss, no-contact orders, formal separation from the victims, financial restrictions, limits on fundraising, monetization, or account control, probation, supervision instead of incarceration, conditions of behavior, therapy, education, compliance monitoring. These outcomes are not getting away with it. They are the system prioritizing stability over spectacle. Why prison is often not the primary tool here. Many people ask the same question. Shouldn't someone go to prison for this? The answer depends less on outrage and more on utility. Prison is typically reserved for violent conduct, repeat offenses, refusal to comply, obstruction or intimidation, large-scale or ongoing schemes. If the system believes the risk can be managed through restrictions and repayment, incarceration becomes a last resort rather than a default. That does not mean the conduct is minimized. It means the response is calibrated. How Patrick's position is likely being evaluated. At this stage, Patrick Rourke is no longer being evaluated as a content creator or a public figure. He is being evaluated as a defendant. That evaluation focuses on financial records, consistency of statements, post-arrest behavior, compliance with conditions, judgment under pressure, public commentary, and failed fundraisers don't determine guilt, but they do inform how stable and compliant a defendant appears. Stability matters. Why ignorance of social media law has limits. One argument that may surface during negotiations is lack of sophistication. Social media monetization is complex. Tax obligations are confusing. Contracts are often informal or non-existent. Courts acknowledge that reality, to a point, but ignorance does not excuse outcomes when vulnerable adults are involved. The law expects higher care, not lower, when capacity is limited. That is why I didn't know can mitigate intent, but rarely eliminates responsibility, where Eric fits into this phase. Questions about Eric Carroll remain unresolved publicly, but silence does not mean inactivity. In many cases, prosecutors narrow focus to the strongest provable conduct first. Separate cases strategically. Keep options open rather than premature. It is common for one person to be charged while others remain under review. That does not guarantee additional charges. It also does not foreclose them. The system moves incrementally, not theatrically. Why public pressure doesn't force prosecutors' hands. Another misconception is that outrage forces action. In reality, public pressure often does the opposite. It makes prosecutors more cautious, more deliberate, more resistant to appearing reactive. Especially in vulnerable victim cases, optics matter. Prosecutors want outcomes that survive scrutiny, not outcomes that satisfy crowds. The quiet signals that actually matter. Instead of watching comment sections, the real indicators to watch are procedural. Do court dates continue without disruption? Or conditions of release adjusted? Are motions filed quietly rather than publicly argued? Does the case move toward resolution rather than expansion? Those signals suggest containment is underway. Silence at this stage is not absence. It is focus. Why restitution is the system's moral center. No matter how the case resolves, restitution remains the moral anchor. Courts care deeply about whether money was taken, whether it can be returned, whether victims benefit materially. Restitution does something prison cannot. It directly addresses harm. That is why restitution often becomes the centerpiece of negotiated outcomes. Why the internet will feel unsatisfied either way. If the case resolves quietly, many online observers will feel let down. There will be no dramatic confession, no viral verdict, no perfect villain arc. That dissatisfaction is not a failure of justice. It is a mismatch between entertainment expectations and legal reality. The system is not designed to provide narrative closure. It is designed to stop harm, the likeliest endgame. Based on similar cases, the most realistic outcomes involve repayment obligations, permanent separation from the Whittakers, restrictions on future online conduct, supervised compliance, a slow fade from public relevance. That is not dramatic, but it is effective. Why this phase matters more than all the noise before it. Everything before this point was reaction. This phase is resolution, and resolution is where lives stabilize or fracture further. For the Whittaker family, resolution matters far more than internet vindication. Where this leaves the story. At this stage, the case is no longer being shaped by posts, fundraisers, or arguments. It is being shaped by documents. And documents do not argue. They decide. We'll close by stepping back from Patrick and Eric entirely and focusing on what this case reveals about online monetization, vulnerable families, and why these situations keep repeating. Because if the structure doesn't change, the names will. Do you think quiet resolutions protect vulnerable people better than public trials? Or do they let accountability fade? When cases like this finally slow down, there's a temptation to treat them as isolated failures. One bad actor, one messy situation, one story that got out of hand. That framing is comforting and incomplete, because nothing about this case is rare. What's rare is how visible it became, the pattern behind the names. Strip away the personalities, and the structure looks familiar. A vulnerable family with limited capacity to protect themselves. A sympathetic public looking for a way to help. A content creator acting as the bridge. Money flowing faster than safeguards. Informal agreements replacing formal protections. That combination shows up again and again online. Different platforms, different creators, different families, same risks. Why vulnerability and visibility are a dangerous mix. Visibility feels like protection. People assume that because something is public, it's safer. That exposure equals accountability. In reality, visibility often does the opposite. It attracts money without oversight, helpers without training, narratives without consent, power without limits. When the people at the center cannot fully consent or advocate for themselves, visibility becomes leverage. And leverage is what exploitation feeds on, sometimes intentionally, sometimes through negligence. The gap no one wants to own. There is a gap between intent and outcome that social media rarely acknowledges. Many people step into these situations believing they are helping. Some genuinely are. But good intentions are not systems. And systems are what protect vulnerable people without written agreements, independent oversight, financial separation, consent protocols. Help turns into control very quickly, not because someone woke up wanting harm, but because nothing stopped it. Why the internet isn't built for safeguards. Social platforms reward speed, emotion, and engagement. Safeguards are slow. They are boring. They require paperwork. They require third parties. They require restraint. Those things don't trend. So the environment itself pushes people toward shortcuts. and shortcuts are exactly where vulnerable families get hurt. Why accountability feels unsatisfying here. Many people will walk away from this case feeling like something is missing. No dramatic ending. No perfect justice. No clean villain arc. That discomfort comes from expecting the legal system to do what it was never designed to do: provide moral catharsis. Courts don't exist to make audiences feel resolved. They exist to stop harm and prevent recurrence. That's a lower volume goal, but a more important one. What actually protects families like the Whittakers? Not outrage, not sympathy, not virality. Protection looks like third-party oversight from the start, money handled by independent trustees, clear consent standards, no exclusive control by creators, the ability to stop participation without consequence. These are not optional add-ons. They are prerequisites. The hard truth this case leaves behind: if nothing changes structurally, this will happen again. Maybe not with the Whittakers. Maybe not with Patrick. Maybe not on Facebook. But somewhere else. With someone else. Under a different name. Because the system that allowed it is still intact. The final question worth sitting with, before the next family becomes a story, the question isn't, who should we trust? It's, what protections exist before trust is required? If the answer is none, then trust becomes risk. And vulnerable people always pay first. Do you think the real problem is bad actors, or the lack of safeguards before money and visibility enter vulnerable lives? Thank you for watching this video. Click here to watch another video that might interest you.